Good morning. This is the matter of GF, case number 23-52207NA. Present in the virtual courtroom, we have Attorney Roman Kosorek, who is here for mother's attorney Renee Wagner. We have father Thomas Fowler, his attorney Katie Tompkins, the child's attorney Ann Lewis, CASA, Ms. Lampin, foster parent, and various agency workers. This was noticed on for a review hearing today, as well as a contempt hearing after arraignment of Ms. Fowler, mother. She was ordered to appear today to answer the contempt charge. This was noticed on for today at 9 o'clock. Ms. Fowler was given the Zoom ID both by virtue of the order after arraignment last week on the 23rd, as well as by virtue of the notice of the review hearing on the underlying case that we're here on today, the NA case, and she's failed to appear. So the court will issue another bench warrant. But we will proceed with the review. Ms. Lewis.
Thank you, Your Honor. For exhibits today, I only have one. I have case service plan and parent agency treatment plans dated February 19th of this year that update the court on how things have been going. I would ask that that be admitted as exhibit 1.
Any objection?
No objection.
All right, submitted.
Thank you. I would call Ms. Andring.
All right, would you raise your right hand, please? Would you state your name and spell it for the record?
Bailey Andring, BAILEY-ANDRING.
Do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. Ms. Andring, can you please spell your name for the record and let us know where you're employed?
Bailey Andring, BAILEY-ANDRING, and I am employed at DA Blodgett St. John's.
And you prepared the reports for today's hearing, which are actually dated yesterday, but the report date is February 19th. Is that correct?
Correct, yes.
Okay. Is there anything that was not in those reports that the court should know?
Yes. So Mr. Fowler has since moved back to Michigan. He moved back around February 20th, I believe, which is just after the report was submitted. And I viewed his residence as appropriate, and visitation began in person between GF and Mr. Fowler, and it has been going very well. They began doing overnight visits over the weekends, and there have been no concerns reported.
All right. What are your recommendations today?
Currently, it is respectfully recommended that GF be released into the care of her father, Thomas Fowler.
Okay. Is that your only recommendation?
It is.
All right. Thank you, Your Honor. I have nothing further.
Thank you. Mr. Kosorek.
Your Honor, I have no questions. Thank you.
Ms. Tompkins.
No questions. Thank you.
All right. Any additional witnesses, Ms. Lewis?
No, thank you.
Mr. Kosorek?
I have no evidence, Your Honor. Thank you.
Ms. Tompkins?
No, thank you very much.
All right, statements, Ms. Lewis.
Thank you, Your Honor. I was able to visit with GF. She is doing exceptionally well in school. She plays the flute. She's up to date on her medical and dental. She had to have some cavities filled, but that's not a big deal. And she is really looking forward to going to her father's house. She's been enjoying the time she's been able to spend with him since he's been back here in Michigan. And I would ask the court to follow the recommendations. She is really, really doing well in school. Like, she's on the honor roll. She was complaining to me about a B- the other day, but they hadn't put a test result into her grades yet. And she actually has an A. I told her, a B- isn't all that bad in math, of all things.
Yes, really.
So yeah, she really is taking pride in her schoolwork and her participation in band. They're going to play at Michigan's Adventure, and then they get to go on the rides and stuff afterwards. So she's really excelling. I think the recommendation is more than appropriate, especially after all of this time. And we finally have a good end of the road. So I would ask the court to adopt the recommendations.
And just to be clear, you're asking that the court case be closed or that it be continued and we set another review hearing?
I would ask for maybe one more review hearing.
Okay.
But after that, I don't see any reason to keep things going.
All right, thank you. Mr. Kasorik.
I take no positions on the recommendations, and I would simply ask that this court consider giving my client an additional 24 hours to report why she wasn't here before the court issues a bench warrant. Thank you.
All right, thank you. Ms. Tompkins?
Thank you. I support the recommendation. My client's a non-respondent, and I would actually commend him for kind of the grace he had, and allowing the kind of delayed process rather than, forcefully trying to assert his rights, and for making sure that he moved back here, leaving everything he had there to make sure he moved back here, because that's what was best for Grace. So, I think everything is going well. I support the recommendation. And I'm not sure where mother resides. But if it is in Kent County, I would ask the agency to help at least with resources on Mr. Fowler filing for divorce or some kind of custody order. Thank you.
Great, thank you. The court finds that the lawyer guardian ad litem has complied with the requirements of the statute, that reasonable efforts were made to preserve and unify the family, make it possible for this child to safely return to a parent's home. That in accordance with the statute, the child's continued placement is no longer necessary or appropriate. The court orders that this child continue in the protective and temporary custody of the court and be released to father, Mr. Fowler. And we will set a review hearing for, do you want 90 days or 60 days?
Well, 60 days would put us at the end of the school year. That's probably a good benchmark.
That's kind of what I was thinking. All right, we'll set one for 60 days from now. Ms. Gibson, do we have a date?
Yes, Your Honor, we could do Tuesday, May 26th at 2 p.m.
That works for me.
I have a 2:30, but I don't imagine this hearing will take that long, so that works for me.
I will let Attorney Wagoner know, Your Honor. Thank you.
Okay, and please convey to Grace how proud I am of how she's doing in school.
I will make sure to do that.
And thank you, Ms. Fowler, sister Ms. Fowler. And again, Mr.
of
Fowler, I'd
course.
also like to add my thanks for the efforts that he's made here and the patience that he's exhibited with the system and all in her best interests. So really appreciate that. All right, thank you. Sisson versus Sisson, case number 19-004-474 DM. Present in the virtual courtroom, we have both parties as well as Ms. Van Tol representing Ms. Robinson. This is the objection, or I'm sorry, this is this is the order to show cause in this matter. Ms. Van Tol.
Thank you, Your Honor. As I indicated in my pleading, Mr. Sisson took to the children following the consent order in which the parties agreed to modify parenting time and asserted to them that it was all my client's fault, that he's not going to be able to see them anymore. It was just a very clear violation of the inherent rights. My client addressed it with him. He admitted it in the phone, and then he admitted it again in text messages, which were included in the motion that I filed. What my client is really looking for, Your Honor, is to stop this type of behavior. Mr. Sisson also violated the court order by not providing a breathalyzer prior to his parenting time as he was required to. He did it late. He's supposed to do so with an hour of parenting time, and he also, while he didn't blow at the limit, he was late, so we have no idea on whether or not he would have blown above the limit that we have in the order. So all of these things are concerning. My client really just wants Mr. Sisson to follow the court order, to not alienate these children. And obviously, as I indicated in my motion, Ms. Robinson has been agreeable to Mr. Sisson having contact with her own daughter as long as it's appropriate, because he was engaged in her care while they were together. And she's trying to maintain that contact, but doesn't want to have that step back because of his behavior. So again, we're really just trying to impress upon Mr. Sisson that this is important, that the kids' best interests are not met by him disparaging and blaming my client for a consent order. Thank you.
Mr. Sisson?
Yes, Your Honor. My apologies for representing myself. So if this is a little clunky,
That's your right.
well, my attorney's not available and I didn't have enough time to find new representation. The conversation that I had with Gina about discussing the new agreement with the children, she had called me and asked when I would like to speak with the kids together. I informed her that I had already spoken to the kids. She was frustrated, and so we made the conversation as brief as possible. I gave her the Cliff Note version, and there are some items in the motion that are not accurate, and I can walk through those, but there are some, I mean, there's certainly some that are true, and
Okay, why don't we start with the ones that are true?
the ones that are true. When my son asked me if, what if we just don't follow the motion or the agreement, I said, there are legal consequences to that. And he said, like what? I said, I could potentially go to jail. The question caught me off guard. And if I took that answer too far with him, I'm sorry for that. I was caught off guard and could have definitely handled that with more finesse.
Okay.
Okay.
Anything else?
The second one that is true is I did threaten to tell the kids about the child support. If you read through the text, there were some accusations made towards me by Gina, the plaintiff, and I was frustrated. That was said out of spite. I had no intention of telling the kids, would not tell the kids, did not tell the kids, because even I can see that that would be a clear violation of our custody agreement. So that was said out of anger, and I should not have done that. And Gina, I'm sorry for that.
Anything else?
It says that I specifically told the children that Gina took my time away. Did not use that wording. I said that I would have less time with them during the school year, but it'd be made up during the summertime. Oh, are you still looking at truthful points? I'm sorry, I transitioned there.
That's all right. Are you done with the truthful ones?
I mean, did I tell the kids that I tried to fight it? I didn't use that wording. I said that I requested that the time be kept the same. And based on the recommendation of my attorney, I was encouraged to sign the agreement, and I did. So the wording on that one is a little inaccurate, but the statement, I guess, could be taken as truthful.
Okay.
And I think that is about it.
And the rest of it you're saying is not true.
Especially point number 5. That is an assumption. And I can tell you that I told the kids all the things that we can do during the summertime. Told them that we could go up to our family cottage more, which they were thrilled about. Told them that we could go boating and tubing more, and they were thrilled about that, and that we could travel more. And they were ecstatic about all those options that we could do during the summertime.
What about the issue with the breathalyzer?
I don't know. Sam, are you talking about the one where I didn't go and pick up the kids?
Correct.
That was my misunderstanding. I informed Gina that I was going to be in an interview at the time that I was asked to pick up the kids. I read through the agreement and did not see or recall that point where I had to blow even if I was not picking up the kids. It was in the transportation section of our agreement and not in the breathalyzer part. And so I didn't think I had to. Gina pointed it out, sent me a copy with it highlighted. And so I took one immediately with her.
Okay. Do you understand that in the future you cannot do that?
Yeah,
You've got to
absolutely.
follow the order.
Yep.
All right.
That
All right.
was my mistake.
All right. I think with the admissions that were made today, it is clear that the defendant is in contempt. These children should not be brought into this conversation in any shape or form. Even questions that they're asking about the court case, you should not be getting into any kind of detail with it. Let's just keep them out of this because they already align. Well, they already feel that there are 50% of each parent. All children do, and so they're going to blame themselves and internalize any criticism that you have of the other parent, even out of frustration. And you're the adult, and you need to be. I understand the frustration, but you need to be able to restrain yourself. I will award attorney fees for this motion, but I will hold them in reserve. So long as there are no future violations of the order.
Your Honor, can you explain what holding them in reserve means?
It means if you are found guilty of contempt in the future, that not only whatever fines or sanctions there may be for a future violation, this will have to be paid as well.
But I don't
And
have to pay, I don't have to pay it unless I'm
right.
okay.
And Ms. Van Tol, did you have a total on here?
I don't know, I'll submit an affidavit because I did want to include today's hearing and I didn't know whether the court was going to schedule an evidentiary hearing. So I
Yes,
just wanted
yeah.
to make sure we do that.
We'll submit or I'll ask Ms. Van Tol to submit a bill. That way Mr. Sisson can look at it, and if we need to have a hearing on the reasonableness of the charges, we can do that. But again, the court is simply holding whatever that amount turns out to be in reserve, so long as there are no future violations. This is the matter of EG and SC case numbers 22-51687, 22-51884 in A. Present in the virtual courtroom, we have Mother Diamond Jones, we have Father Mr. Gregory, we have Mother's attorney Jessica Lowry, Kendra Ortega, who represents the children, and attorney Stephanie Cardenas, father's attorney. We are here on Mother's objection to the ex parte order suspending parenting time. Ms. Lowry, sorry.
Thank you, Your Honor. Yes, this is just my motion. We did object to the ex parte order, which suspended Ms. Jones's parenting time following some parenting times in early December. Essentially, I think I laid out most of the facts in the objection and motion, but we are asking to reinstate her parenting time following the parenting times that were referenced in the ex parte order. A family time safety plan was completed and signed by Ms. Jones and the agency. And on that date on December 15th, there was a parenting time that was held and things went well. There were not any safety concerns for the children. Lots of hugs and kisses and I love yous at the end. And so I think the ex parte order was signed maybe the next morning, but we would ask to reinstate her parenting time so that she can continue to visit with her children. I know she was upset to miss her son's birthday. He just had a birthday, and birthdays are big celebrations normally for their family. So I would ask that the court reinstate her parenting time. I don't believe there's a risk to the children, and I think all the attorneys have been able to view some of the parenting times, that one as well as the ones before. And so I would ask that her parenting time be reinstated.
Ms. Ortega?
Thank you, Your Honor. I filed this motion upon prompting of the agency that things had been really not going well in parenting times and just overall participation in services for Miss Jones. I did review the parenting time at question. It was very, very concerning, the things that were being said to the children. I understand there's emotional heightened emotions everywhere here because we're headed likely towards a guardianship situation. However, we're not headed towards termination. But the statements made by Miss Jones during that parenting time were clearly upsetting the children. They were crying, and then she was yelling at them to not cry. And it just was not productive. And this is before any type of interference or potential interference from a caregiver took place. And it's my understanding that Miss Jones is no longer participating in counseling. She started DBT and stopped that. And so because of that, Your Honor, I think that a break in parenting time is appropriate at this point. I think, especially from what I saw, it's harmful to the children. And so we do have a hearing scheduled in this matter, January 6th, where the worker can testify more about what's been going on, what services are happening and not happening. And so I'd ask the court to set this matter to be heard on Tuesday more clearly and have more evidence presented and make a determination at that time if continuing suspension is in the best interest of the children and is harmful to their mental and emotional well-being, or if supervised parenting time can resume. I understand the allegation is that there was one more parenting time before the order was in place that went well. I do believe the reports from the agency would contradict that. We did not have the same emotional outbursts and things happen at that one, but there were certainly still concerns.
Thank you. Ms. Cardenas?
Thank you. At this time, my client does not wish to take a position.
All right, thank you. The court obviously is very familiar with this case, and we do have a, Ms. Jones, you're not, I'm going to ask you to put your hand down. You have an attorney and you're not allowed to speak in a motion. The court, again, is familiar with this case and has reviewed all of the records. And at this time, since we do have a hearing coming up on January 6th, I will simply adjourn this objection to be heard at that time when we have more time to devote to it. All right, thank you.
Thank you.
Thank you,
We're
Your Honor.
adjourned. Great. Good morning. This is the matter of Luna versus Bueno, case number 25-006-791-DS. Both parties are present in the virtual courtroom, as well as Mr. Gonzalez from the prosecuting attorney's office. This is the prosecuting attorney's office motion to enter a judgment of support. Mr. Gonzalez.
Yes, Your Honor. If it pleases the court, I would like to put this matter on the record. A summons was issued on 7/30/2025. Proof of service was proper and received on 8/19/2025. The defendant answered on the same date. A pre-hearing conference was held on December 2nd, 2025. And during that conference, both parties attended. What was discussed was the family income, imputed income, medical share. So the plaintiff's net family income is $2,226.60. Imputed income was at $20 at 35 hours a week. Medical share was 52% for the plaintiff, 48% for the defendant. There is one additional child for the plaintiff, and there was 365 overnights. Excuse me, Your Honor, let me confirm that. There was 360 overnights for the plaintiff and 5 overnights for the defendant. The defendant's net family income was $2,079 at 6, and it was an imputed income of that same amount a month. The defendant is no longer in jail. There is a new address on file, Your Honor, and I just want to confirm that the court has that new address, which is 9037 Bricksville Drive, West Olive, Michigan, 49460. The base support was $483. The ordinary medical was $8, and the grand total is $491. Thank you, Your Honor. If it pleases the court, I would like to enter that in a judgment of support and a uniform child support order.
All right, thank you. Ms. Van Oler, can you confirm that that address for Mr. Bueno is up to date in our system?
The address was, please repeat it. I have it. I'm looking at it, but.
9037 Bricksfield Drive, West Olive, Michigan, 49460.
Brickersville?
Um, yeah, yes.
Okay,
B.
perfect.
Do you want me to spell that for you?
I have Brickersville.
That's correct.
Yes, that looks like that was updated late August 2025.
Okay,
Okay.
wonderful.
Thank you. And Mr. Bueno, do you have any objection to the motion? You can unmute at this point.
What was, I don't know exactly what it is, the motion. I understood,
Did you receive a copy?
yes.
Okay, and can you read and write the English language?
Yes.
Okay, so what part of it do you not understand?
I don't understand like the what he was explaining. Not clear.
Okay, bottom line is you're being asked based on your income and Ms. Luna's income that support for this child should be $491 per month.
Yeah, I was really not, I'm not able to pay that. And I was why I'm like, I'm still not like, I have no job. Like, I'm still like struggling financially with a lot right now. So like, I'm not sure how to go about that. If there's a way like that, I do
Mr.
want to help
Gonzalez,
out. I do want to
Mr.
help out.
Gonzalez,
So I imputed him at a lower amount of $15.50 at 35 hours. But Your Honor, he does have incarceration. He does have a misdemeanor, and he did recently get out of jail. He was released on September 29th, 2025. So, Your Honor, I can leave it to the discretion of the judge. If you want to impute him at a lower amount, I can rerun the amount and lower it to maybe $14. But Your Honor, I do believe that he is capable of working. He does have a high school, a part of the imputation factors in determining his income. He does have a high school diploma. He is approximately 26-year-old. He does have work history. His previous employer was at Porter Corp, where he was making approximately 20 hours, working 40 hours a week. And his previous employer was also at Libata at $18 and 40 hours a week. So, Your Honor, he is capable of work. There is the barrier of him having a criminal record. So that could be a little more difficult for him to find employment. So I tried to impute him at a lower amount, to be fair, at $15.50. But Your Honor, if he would like a little less, Your Honor, I can agree to that. The available opportunities to work in Kent County, the unemployment rate as of August 2025 was 5.30. The prevailing wage was $12.48 as of February 2025. His geographical area is fine, Your Honor. It's in Kent County, so he should
I
be
believe
able to
West
find
Olive
employment.
is Ottawa
Yeah.
County.
Yeah.
West
Okay,
Olive is Ottawa County.
Yeah. Correct.
okay. So unfortunately, I do have the Kent County information, Your Honor. So,
All right.
the Kent County was
All right,
$5,
well,
5%, 5.3.
all right. Thank you. I think this court can take judicial notice, however, of the fact that Ottawa County, particularly West Olive in that area, is very similar. Mr. Bueno, is there some reason that you've been out since September? Is there some reason why you can't work at a fast food restaurant or something?
I'm not sure even like if I would even be able to work at a fast food restaurant
Have
right
you
now.
applied?
I've applied like to like numerous places. No, I haven't
Like,
tried to not
hold
to a
on,
fast food
just
restaurant.
answer my questions, okay?
Not to a fast food
Where
restaurant.
where have you applied?
I've applied to Amazon. I've applied to numerous like jobs on Indeed. I've like through Guild Staffing, through like numerous temp agencies, and it's like very hard through them, like with my record, and as well as
Okay,
like
all right, hold on. What is your record? Do you have any felonies on your record?
I do have felonies. I have like a extensive like record. It's not just like a misdemeanor like he was saying. It was
Okay.
like it's like more like it's more. It's like
How
I do
many
got like a felony.
felonies do you have?
I believe I got like two felonies, a felony or two, and then I got
Okay.
like multiple like misdemeanors, which
Okay.
is
How are you supporting yourself right now?
right now like I can't. My mother's the only one that's helping me right now. Like
Are
right
you
now,
living
she's
with
the
your
one.
mother?
Yeah. That's the address that I'm at right now. Yeah, my mother's.
Okay.
So she's the one that's really trying to help me like get on my feet because it's really been like a struggle for me like financially So like she's really been like the only one that's like helping me ever since like I got out of jail, especially. So it's been like, because I was
Okay.
working before I got incarcerated. So like now it's just like.
Okay, all right. Ms. Luna, do you have anything you'd like to say? Unmute, please.
No, I don't. Just I was. Oh, yes, I do. Sorry. I was okay with the original amount.
What was the original amount?
I think it was at 195 a week, around there. Is that right?
Are you receiving public assistance?
No, not at the moment. Just Medicaid for my daughter.
Okay.
She's on her separate own case though. Since she has a disability. And then I just.
Okay, hold on. Mr. Gonzalez?
Your Honor, the child has a disability, but Reina's income was imputed at the appropriate amount
Okay.
for $20 at 35. And quite frankly, Your Honor, the income of the plaintiff doesn't really make that much of a difference. It's about the overnights and the defendant having overnights with the child and the amount of money that the defendant makes.
I understand. I guess my question that I'm trying to get to is Ms. Luna receiving any public assistance? She said she's just receiving Medicaid.
Oh, yes, Your Honor. That is, let me confirm that. It does appear to be that, Your Honor, that she's just receiving Medicaid according to my notes.
Okay. All right, Ms. Luna, would you unmute? And why, you said you were okay with the lower amount?
I was okay
Why
with
is that?
No, with the original amount. When me and Gonzalez and Bueno had the first meeting, when he calculated the Michigan calculator.
Okay, I understand. What my question is, why? Why are you okay with a lesser amount of money? It doesn't sound like you're in great financial shape yourself.
When that was calculated, I had thought that was the base, like, nothing was said to me that was minimal. That was just what was
Okay, all
calculated.
right. That's not my question. Why do you think you can support this child on that amount of money from him, that low contribution from him?
Oh, I cannot. No,
Oh, then why are you okay with that amount?
I'm not.
Okay, that's not what you said when you first started talking.
Okay.
All right. The court finds that the imputed income that was proposed by the prosecuting attorney's office is appropriate based on all of the child support imputation or potential income factors for both parties, and that that support should be at $491 a month. However, I will delay the commencement of that support until February 1st to give Mr. Bueno some additional time to get on his feet. But in this court's opinion, and I can take judicial notice that fast food restaurants in particular and places such as that are begging for people to work. So he can certainly at least do that.